They either have to qualify the report or refuse to issue the report. And that's what we found through our investigative process.
But Claudius, then that goes beyond just simple lack of quality control standards. It goes beyond simple carelessness. It goes beyond not complying with PCAOB standards. To some degree, if I was to be able to use a legal term, this would be gross negligence, wouldn't it?
Well, we don't apply a standard in exactly those terms.
Okay.
I mean, the board's order is based on conduct that is sufficiently violative of our standards, and the facts and circumstances here indicated that there was a failure to follow those standards, and that failure was significant enough for the board to sanction the firms in a very substantial way. And so I think you have to look at the entirety of the order and the violations to get an appreciation for what actually happened here.
All right, but I also want to ask you why you chose to penalize the firm and not take any action against individual partners. But before I come to that, I want to know what the experience of investigating this case was like working in India, because you know, our Indian regulators have had very little or made very little progress with building any coherent case either against the firm or individual partners. Now, there are multiple investigations going on in India, multiple authorities investigating the matter, and that could in a sense be the cause for delay. I'm not asking you for why you think the Indian regulators are delayed, but I would like to understand whether you had access to the documents you needed. What was the investigating environment in India like? How much assistance you got from the SEC, all that helped you come to this speedy decision?
Well, we applied our expertise in investigating audit failures in this instance, and we obtained the documentation that we demanded from the PW firms and from those working at the PW India firms. We were able to examine witnesses in India. We examined numerous witnesses. Several of those witnesses refused to speak with us, and our federal law in the United States gives us the power to sanction persons who refuse to cooperate. And in this case, there are two PW India managers who refused to be examined, and we permanently barred them from auditing public companies. And our coordination with the SEC was very close. We took on a significant responsibility in terms of developing the investigative record. In the United States, we're allowed to share that information with the SEC. That helped us get to a timely and effective resolution of the matter and helped us avoid duplication of effort. And that, in totality, was our investigative process resulting in the enforcement order.
Did you run into any hurdles whatsoever in terms of the multiple investigations that were going on in India?
We did not. We gained access to the witnesses that we needed to gain access to for purposes of this investigation, and like I said, the two did not cooperate, were sanctioned.
All right.
And Claudius, just to clarify, we did not have access to the Satyam records or people. It was only the PW India people and records that we had access to for our investigation, because our authority does not extend to anything beyond the PW firm.
That's correct. In U.S. federal law, the United States Securities and Exchange Commission has the power and authority to regulate and oversee the U.S. public companies and other companies that trade on our markets, such as Satyam. And as you know, the SEC brought its case against Satyam.
Jay, can you explain to me why you took action against the firms and not individual partners that you may have found guilty of this negligence, so to speak, especially if they were the ones trying to reconcile the bank statements with the kind of information that Satyam offered them and couldn't find a match, yet didn't do anything about it? I understand you went after the firms for a systemic failure of quality standards. That I get. But how come you haven't, in any sense, taken any action against individual partners?
Well, I will just comment on that and let Claudius expand that in addition to the 5 PW firms, we have entered into orders with individuals, and as Claudius mentioned, 2 of the individuals refused to cooperate, and so we've effectively barred them from ever working on U.S. public company audits before, but we have entered into settlements with some individuals as well. Claudius, you want to expand on that at all?
In the case, as you indicated, Manaka, in this case, there were quality control violations, and we've addressed that through the use of the independent monitor and the undertakings in the order. And that's important in terms of investor protection and the firm getting it right going forward. And beyond that, I can't comment on the extent of our investigative process. That process is confidential. but I can say that we addressed the firm conduct given the facts and circumstances here. And I'm just reminded that this was a failure to detect a significant fraud. And the larger problem that we found through our investigative process related to a more general practice of failing to comply with PCAOB standards in terms of cash confirmations. And that's why we have a package of sanctions, including what is the largest penalty in our history, and combined with the SEC penalty is the largest for both regulators for a non-U.S. firm. That is in place along with these other sanctions to ensure that investors get more robust audit reports going forward.
No, I understand that, Claudius. What I'm curious to understand is it that PCAOB prefers to take action against a firm rather than individual partners, although you have, like you said, already barred 2 partners on the basis of not cooperating with your investigation. Could it be possible that you could take future action against PW India partners? I'm just curious to know, why is it that you prefer to penalize the firm and not take any action against the partners?
Well, again, Monica, we under our law, our investigative process is confidential.
Okay.
And I can just tell you as a general matter, we always look to see who the responsible parties were for the conduct that's at issue. And so it's not a question of preferring or showing preference over charging a firm versus individuals. We always look to see who the responsible parties are, just as a general matter in terms of our process.
All right, let me move to the next question. And Claudius, I think this goes to you as well. I'm told that the PCAOB, and this is unconfirmed, but I would like to put it to you, had in fact inspected PW India's Satyam files before the fraud came to light. This was, I'm told, a routine investigation. At that point in time, you did not discover these deficient cash confirmation procedures, as you've put them to be, and pervasive failures in quality standards, again, in your words?
I think Jay will take on that question, Monica.
Okay.
Our policy is to not comment on individual findings in the firms, and so we really can't comment on the specifics. But the report that we issued on the PW India firm was just by the nature of this investigation, we decided to release it at the same time. And with respect to the procedures that we perform on any of the non-U.S. firms, we're always looking to improve our process and improve our identification of what we actually look at. For any inspection of any firm in any given company, we don't look at everything whenever we do an inspection. We look at selected items that are typically the higher risk items, and so we don't and therefore we don't always we don't identify the actual issues that we look at, nor the nor what we chose to look at on those issuers.
No, Jay,